for her bill. So this is item number 9, AB 684. Assemblymember Alejo, welcome.
Thank you, Mr. Chair and committee members. I'm here as a joint author of AB 684, joint author with Assemblymember Susan Bonilla. And I'm also the author of AB 595 to urge support of this measure. I want to begin by stating that I share the goal of this committee, the Board of Optometry, the supporters, and the opposition to protect the health and safety of California consumers when they receive eye care from licensed optometrists. The way California working families access vision care in this state has changed greatly over the last 50 years. Many working families rely on co-located models of vision care for services, which include Costco, JCPenney's, Lens Crafters, Sam's Club, Sears Optical, Target Optical, and Walmart. These vision care centers offer working families access to eye care options that are affordable, conveniently located, and offer extended hours, particularly on evenings and weekends. It is estimated that over 2 million people in the state annually rely on these providers for their vision care needs. But despite this need, a lawsuit concluded last year that inserts ambiguity into the ability of these vision models to operate in the state under this current statutory structure. For these reasons, I've authored AB 595, a bill that would have updated that code. But I believe that our vision laws need to be updated in a way that reflects the modern realities and protects optometrists' clinical judgment, which was the goal of that bill. However, to ensure that we work towards finding the proper balance, we made a collective decision not to hear AB 595 this year. We have all recognized that there's a desire to better define regulation of the industry, and to that end, we agreed to continue these conversations. In the interim, we have introduced this measure, AB 684, in order to facilitate stability and preserve patient access, as well as respect optometrists that practice in co-located models. In essence, this bill will suspend any new disciplinary action against optometrists and opticians currently operating in the state until January 1st, 2017, simply because they operate under a co-located model. In light of this discussion, it is my goal to have all stakeholders work productively to seek a solution that ensures patient access, preserves the doctor's clinical judgment, and provides greater transparency for both patients and regulatory entities. With that, I urge I vote on this bill, and I believe my co-author, a joint author, wants to also address, and then we have some witnesses to speak in support.
Thank you, Assemblymember Alejo.
Thank you so much. And I think that this is a very important measure, because what we're really seeking with this bill is bringing the parties together. A little background, we've had a 20-year-long lawsuit that has done nothing to, as it went on, to change this business model. And as you know, the lawsuit was found or the suit was found against Lens Crafters' model because we have the corporate bar. And the corporate bar essentially says that those who are practicing medicine or optometry need to be protected from businesses that might, make them sell a certain number of eyeglasses or this or that in order to stay employed by them. And so we had a situation here where we have existing established businesses in California. They are in violation of California law, and we've got to solve this problem. It's a very difficult problem. Just in the last few days, there's been some movement and some amendments and ideas coming forward, but until we really have both sides of this dispute come together, we actually risk, I believe, another lawsuit that could leave things the way they are, unresolved. And we really do need to resolve the issue. This is the law in California. It is our duty to make sure that we have a way to uphold this ban of undue influence, and I think we can get there. I hope we can get there by the end of this session. If not, we do need this in place, or we actually put at risk a number of these businesses and a lot of optometrists who actually work in these businesses. And of course, we have optometrists on the other side of the issue as well. So this is a very typical BMP type of issue where we have many folks on different sides, and really the purpose of 684 is to bring everyone together to actually bring about a solution that is workable for both sides of the issue.
Very good. Thank you very much. I see no questions at this point. Witnesses in support.
Mr. Chair and members, Thank you. Mr. Chair and members, Megan Loper on behalf of the National Association of Optometrists and Opticians. We are the trade association that represents several of these models, several of the ones that Mr. Alejo mentioned. In addition, IMART Express, Four Eyes, and some additional members are also part of the NAOO operating here in California. So it's a large and diverse group, not just some of the big names that you've mentioned, but there's several players operating in this space that are concerned about making sure that Californians continue to have access to eye care, that it's high quality care, that doctors are able to practice to the full scope of their clinical judgment without undue influence. As you heard, we were the sponsors of Mr. Alejo's previous bill, but respected the feedback that we received from Chairwoman Bonilla and the committee as we worked on that measure, that there needed to be additional work done with the regulators to make sure that we were proposing a statutory change that really did update the law and gave the medical board, the Board of Optometry, and the Attorney General's office the appropriate oversight and communication between those agencies in order to really make a significant change to the statute, which has not been amended in several decades. So we are in support of 684. We think it gives us the appropriate time to have those conversations in earnest. We are pleased that there's been movement, but without knowing where the regulators fall on some of these proposals and without having time for all of our members to digest them, we really feel that 684 gives us the appropriate time to do so, and would urge your support of this measure.
Very good. Thank you. Others in support?
Good afternoon, Mr. Chairman and members of the Senate. I am Dr. Avni Patel. I practice here in Sacramento with Eye Exam of California. I joined the employed model in 2009. My priority when I graduated was to pay off a mortgage-sized student loan and be able to provide patient care. As I started working and seeing patients in this model, I realized that we provided a great quality, a high-level quality of eye exam. We consistently got that feedback from our patients. This is the best exam that I've ever had. I've never had my blood pressure tested before during an eye exam, things of that nature. As I continued to practice, I also realized that accessibility was a significant issue all across the state. We have several locations that are able to provide patient care, not only in more metro areas, but also in remote areas like Redding, Fresno, Bakersfield. We have appointments available for our patients on the weekends and in evenings so that anybody who really needed an eye exam could make that fit into their schedule. I ask for your support in this bill so that we can continue to care for our patients and provide the eye care that we strive to achieve for our patients. So thank you for that.
Thank you very much. Others in support?
Catherine Asta Scott, representing Eye Exam and Lens Crafters. I do need to just clarify a point on the legal issues. The lawsuits upheld the constitutionality of California's law. Unfortunately, as the chair pointed out, we would engage in continued litigation because there's not been a declaration by the courts that the co-location models, including those that use the health plans and the like, is illegal. So we would continue that legal ambiguity going forward if we don't find clarity. And the importance of that clarity is that we honor all the models that currently exist in the state. So we're in support of 684 moving forward so that we have the time to work through that clarity.
Thank you very much, Ms. Scott.
Mr. Chairman and members, Barry Brokaw on behalf of the 185 Sam's Clubs and Walmarts that provide optometry service through a leased tenant lessor relationship. We have a landlord relationship with independently employed optometrists. We want to be able to continue that relationship, and we are supporting this bill very strongly. We're also working on a long-term solution, and hopefully we'll bring that to conclusion, hopefully before the end of next year, hopefully this year. We're in discussions to actively do that, but we think this is incredibly important that this bill move forward at this time. Thank you very much.
Thank you, Mr. Brokaw. Good afternoon.
Good afternoon. My name is Dr. Jeffrey Cohen, and I'm an employed optometrist in Simi Valley, California with Eye Exam of California. I'm also a major in the Air Force Reserves based at the March Air Force Base in Riverside, California. Just last month, I declined my own sublease opportunity as this would interfere with my military obligation and performance. I support Bill 684.
Thank you. Yes, sir.
Mr. Chairman, members, I'm Elliot Grossman, Dr. Elliot Grossman. I'm the president of Eye Exam of California. and I'm here in support of AB 684.
Thank you very much. Good afternoon, sir.
Good afternoon, Mr. Chairman, member of the Senate. My name is Dr. Ryan Abul Hassan. I practice optometry in Southern California. I'm employed by Eye Exam of California, and I support Bill 684.
Thank you.
Mr. Chairman and committee members, my name is Dr. Taylor Tedder. I practice in Thousand Oaks, California, and I'm in support. Thank you.
Thank you very much for coming.
Mr. Chairman and members of the Senate, my name is Dr. Corey Hawkinen. I practice for Eye Exam of California in Fairfield, a little bit south of here. I'm in support of 684.
Thank you for coming. Thank you for your testimony. Yes, sir.
Good afternoon, Chairman and members of the board. My name is Dr. Brandon Zeckler. I'm an employed model with Eye Exam of California in Oceanside, California for the past 3 years, and I'm supportive of this bill.
Thank you.
Good afternoon, Mr. Chairman and members of the Senate. My name is Dr. Dana Nakagawa, and I've been employed with Eye Exam of California for 25 years, and I am in support of 684. Thank you.
Thank you.
Good afternoon, members of the committee, Mr. Chairman. My name is Dr. Del Lamb, and I practice in Lakewood, and thank you.
Thank you.
Good afternoon, Mr. Chairman and members of the Senate. My name is Dr. Michelle Brem. I practice in the San Francisco Bay Area, and I've been with Eye Exam in California for 5 years now, and I am in support of this bill. Thank you.
Thank you very much. Good afternoon.
Good afternoon, Mr. Chairman and members of the committee. My name is Dr. Mary Tran. I have been employed with Eye Exam California for 4 years, and I'm now practicing in Menlo Park, and I'm in support of 684. Thank you.
Thank you. Yes, sir.
Good afternoon, Mr. Chairman and members of the committee. My name is Dr. David Cotto. I practice in Culver City, California with Eye Exam of California for the last 25 years. So I'm in support of AB 684. Thank you.
Thank you very much. Good afternoon.
Good afternoon, members of the committee. My name is Dr. Kristen Kaneko. I am employed by Eye Exam of California in Santa Monica. I've been there for almost 20 years, and I am fully in support of this bill.
Great. Thank you.
Good afternoon. My name is Dr. Crystal Gibson. I am employed by Eye Exam of California. I practice in Whittier, California. I've been employed for 4 years, and I support 684.
Good. Thank you very much for coming. Good afternoon.
Good afternoon, Mr. Chairman and members of the board. My name is Dr. Meredith Barber, and I've been with Eye Exam of California for 5 years, practicing in Los Angeles, California, and I support AB 684.
Thank you. Yes,
Good afternoon, Mr. Chairman and everybody on the committee. My name is Dr. Janet Kim. I've been employed with Eye Exam of California for now 14 years, practice in Orange County, and I support Bill 684.
Very good. Thank you for coming today.
Thank you. Mira Morton here on behalf of the California Chamber of Commerce, also in support.
Very good. Thank you.
Good afternoon. Angie Minetti with the California Retailers Association, also in support.
Very good. Thank you, Angie. Good
Jennifer
afternoon.
Simoes with the Medical Board of California. The board would like to thank the authors for taking the recent amendments, and with those amendments, we're now neutral on the bill. Thank you.
Thank you very much for coming. Any others in support? Seeing no one. Those in opposition to the bill, please come forward. Mr. Valencia.
Mr. Chairman, John Valencia here representing VSP Vision Care. We were founded in California in 1955, and today we cover over 12 million Californians and over 76 million Americans as a health insurer. And remarkably, during that entire time, we've managed to respect California law, California Consumer Protection Law, which is as valid today as it was in 1969. You've heard today that there will be certain beneficiaries of this measure. And those beneficiaries of this measure are outlined in the urgency clause as in need of protection. Those various businesses, et cetera, that are engaged in business relationships prohibited by BNP Code Section 655 and 2556. Here's what the Board of Optometry says about those two codes. In an article in September 2013 that they were requested to remove from their website by the Department of Consumer Affairs, which also offered to rewrite it for them. And here's what the department found so alarming. The highest priority of the board is to protect the public. The intent of Business and Professions Code 655 is the same as it was when it was enacted in 1969, to prevent interference with the optometrist-patient relationship by optical companies and retailers, and to ensure that all medical decisions are made by the licensed optometrist. The optometrist-patient relationship is built on trust that should not be abused, and the board is mandated to prevent that from happening. And yet, that was rescinded. So I would share with you one thought about how long this debate over crystal clear consumer protection laws has been going on. In fact, let me touch on the mythology that there's anything short of clarity about the law. There hasn't been a law, certainly not a consumer protection law that I can think of, that's been litigated for the better part of 20 years. In fact, here's how the Attorney General described this long-running debate in 2011, over 4 years ago, June 22nd, 2011, when, in commenting on then AB 778, in remarks that are eerily similar about this bill, the Attorney General said, quote, "We understand the purpose of this bill is to provide a safe harbor for large optical retailers from the provisions of Business and Professions Code sections 655 and 2556, which are intended to protect patients by ensuring the independence of practicing optometrists through the prohibition of financial relationships between optometrists and optical companies and retailers." As you may know, the Attorney General added, for nearly 10 years, and this is in 2011, for nearly 10 years, the Department of Justice has been engaged in active litigation against the sponsor of that legislation, a proponent and beneficiary of the current legislation. First, to compel compliance with these Business and Professions Code sections. To compel compliance, not to interpret, not to find declaratory relief, but to compel compliance. And then to defend the constitutionality in federal litigation launched by the optical industry and NAOO, the case you've heard cited. In that correspondence, the Attorney General disputed the notion, and again, that was 2011, probably less than 30% of the time that's been occupied in debating these consumer protection statutes. The Attorney General went on to say, you don't need quote-unquote safe harbor, since these are criminal protection statutes, you might also characterize them as get-out-of-jail-free cards. You don't need a delay in the resolution of the issue because the original case in 2002 had a tolling feature that said that the AG would engage in no less than 12 months of dedicated, concentrated conversation with the litigants to resolve the issues. That was in 2011. This bill is yet another chapter in a long-running saga of delay and delay and delay. Mentioned to the proponents that there's no milestone to give you any assurance that will be any further toward a resolution of the matter. And the resolution of the matter is comply with the law. You might also examine the internal inconsistency in the bill itself, because while the bill benefits, and I would direct your attention to page 3 of the bill, lines 10 through 15, the bill's beneficiaries are those engaging in any business relationship prohibited by Section 655. And yet you continue to hear equivocation by those that think they might be beneficiaries of the bill, but don't necessarily want to admit that they'll be beneficiaries of the bill. But then the bill goes on to say, in the very next section on line 12, nothing in this section shall be construed to imply or suggest that a registered dispensing optician or optometrist engaging in any business relationship is in violation or is in compliance with the law. So which is it? Who is to benefit from the bill? Who will step to the plate and tell you, yes, I have a business relationship that violates 655 and 2556, and I need this bill? We respectfully oppose the bill. Thank you, Mr. Chairman.
Thank you, Mr. Valencia. Others in opposition? Mr. Berg?
Thank you, Mr. Chairman. Cliff Berg here on behalf of the California Optometric Association. First off, regarding this bill, I wanted to thank the joint authors. I think they have been, very thoughtful in their approach to this issue this year. They convened early in the year stakeholders groups to work on this issue to try to get a resolution. It did not appear practical, and rather than try to jam through a solution that favored one side or the other, they have taken the approach of this moratorium. Having said that, we have been working closely with a number of the stakeholders over the last couple of months who have reached out to us to try to get a solution this year. I think there's a growing consensus that a solution this year would be a better alternative than a moratorium if possible. So we intend to continue to negotiate with all the parties in good faith to try to reach a conclusion this year and perhaps use this bill as a vehicle towards that if things work out that way. Therefore, as of today, for the purpose of today's hearing and giving the timing of the California legislature and the deadlines, we have no objection to moving this bill forward today at this time, and hope to continue to work with the stakeholders to resolve this issue this year rather than face the question of whether a moratorium is really the best way for the California legislature to respond to the situation. So thank you.
Thank you, Mr. Berg. Others in opposition or halfway?
Eric Robles on behalf of the United Nurses Associations of California, Union of Healthcare Professionals, and our optometrists. We're in opposition, but we fully support every effort to resolve this issue this year, so we're willing to keep working, but we respectfully oppose.
Good. Thank you very much. Others in opposition? See no one. Bringing it back to the committee for questions, and I think that was encouraging, what I just heard. Because I think, and from what I've read and what I understand and in talking with the author, the goal is to accomplish something, to get some type of an agreement sooner rather than later. And the goal this year is to do it now. And I think from what we've also heard is that there's not much of a willingness to extend this beyond whatever moratorium is established. And if there is one, that if an agreement can't come together. So I think it's incumbent upon us to push that issue and try to make sure that there is an agreement, and if not, then enforcement will eventually take place and move it in that direction. Senator Jackson.
Yeah. First off, in response to the chair, my inquire, there's this desire to keep the conversation going, but will the bill then come back to us as it is further amended going forward? Are we in some kind of a time deadline? Because I hesitate. We don't know quite what the fix is. I suspect nobody knows quite what the fix is, and we'd be giving up. Are we relinquishing our jurisdiction over this bill if we sort of acquiesce in the effort? I totally understand it, but I mean, are we no longer going to be able to have any input if we pass the bill out of this committee today in the hopes that the parties will keep working?
No, it's my understanding if this bill were to move forward today as written and it is amended, and before it comes to the floor in the Senate, which we have plenty of time on that, as you know, then we would bring it back to the committee for discussion if it were on the floor.
Okay. Thank you. May I make
Of course.
Thank you. I'm a little bit confused here. And if you just, the timeline, well, I'm really confused about this bill, but I'm beginning to think I'm not alone, so I don't feel quite so bad, and I'm willing to admit that I am confused. As I understand it, there's been a law in the books for the past 20 years prohibiting this kind of model, this kind of business model. And yet, we have people who came from all parts of California to testify they've been working for companies doing this kind of model for at least 25 years. Is that correct? Is there...
Senator Jackson, there has been past lawsuits, and as Catherine Scott mentioned, the lawsuits that have been decided to date have not ruled on the underlying business model. The last case that was heard and went all the way up to the Supreme Court was about the Dormant Commerce Clause, and on that clause, the court ruled that the state's laws were constitutional. They did not make a determination about the business model per se. They did make a determination that the state was within its right to have the law that is on the books. The challenge is that, as you've heard, there's a variety of different models that operate in the state. Some are a subleasing model. Some are through a Knox-Keene plan licensed through the Department of Managed Health Care. Others have a sublease model with an intermediary. So there's a variety of different interpretations. And the ambiguity that's been created is that some think that they're compliant, but given these lawsuits and given consumer class action suits, there's a question that remains. And so I think our desire is to see it clarified in 14 jurisdictions, direct employment is allowed. Now, that may not be a conversation that is appropriate for California. In 47 states, there's a direct landlord-tenant relationship allowed. In 49 states, optical companies are allowed to franchise to optometrists, and all 10 Canadian provinces allow for direct landlord-tenant relationships. So as you can see, other states and other jurisdictions have made interpretations that are appropriate for them. We feel that given that California's demographics are what they are and that the state is as large as it is, that there's room for a variety of models that do protect consumers, that respect doctors' clinical judgment, and with the appropriate statutory construct could give the regulators the appropriate information to be able to do their job of overseeing their licensees. So we do feel that it's appropriate that the legislature consider one of those fixes. We think that the conversation has been encouraging because there's been some movement of the parties, I think, as a result of AB 684. It has encouraged parties to really come together in a place where there hadn't been as productive conversations in the past.
So if I can translate that, as I'm understanding what you're saying. So for the last 20 years, there hasn't been agreement as to which of those models that you've identified comply with California law. Is that, I mean, is that an accurate statement?
I'm not an attorney, so I'm...
Well, I am, and I'm still confused, so bear with me if you will.
So, you know, I'm hesitant to make legal pronouncements because
Okay.
I'm not.
So
You're
let
probably
me
more appropriately
rephrase it
situated
then.
for that.
Let me rephrase it. For the last 20 years, given that there's been litigation, there is no agreement, there's no consensus
Correct.
on what exactly would fall within the accepted parameters of California law. And as a result, we have a variety of different things like a landlord-tenant, but the underlying concept, as I understand it, is to try to make sure that we protect the consumer so that we don't have people who are sort of in a, if you will, maybe a vertical relationship with the same employer, so that the person who does the exam then doesn't then also, for the sake of the employer, then prescribe certain type of glasses. I think LensCrafters, one of them, I know they make glasses, so that we're not talking about sort of again, a vertical company that provides each one of those services because the state has been concerned that that might not be protecting the consumer. Is that a fair statement?
I think that's correct, and I
Okay.
think Mr. Alejo's bill, AB 595, did focus on many of the tenets that we heard from stakeholders in those early meetings about protecting the consumer, figuring out what were the appropriate statutory limitations to make sure that those safeguards were in place. And I think our hope is to see if we can reach that place.
So given this particular bill, AB 684, is there, within the bill or as it's being discussed and modified and amended, a discussion about what is going to best protect the consumer, or are we just kind of looking for a model that's going to fit the state?
I think we're looking, all the conversations, as was mentioned earlier, from the very beginning of this legislative session, we brought the stakeholders together and trying to find the right balance and try to find that middle ground. I took on...
But I'm sorry, a middle ground between what and what?
Well, to all concerned, the balancing the interests, protecting the doctor's independent judgment,
okay,
and also looking after the consumer's interests, and then looking at these new co-located models and trying to find what's the right balance to provide in a bill. As we moved forward, we knew we needed more time. We also have, this part of this current bill before us today was also done in consultation with the Chief Enforcement Agency, which is the Attorney General's office. And I said this has gone on for years, but some of the most recent decisions, I think the last one in 2012, created this ambiguity that we have there. So our role is to not let problems become the saga of delay, but to actually solve them and hopefully done before the time I leave the assembly.
What does co-located mean? Co-located, I mean, isn't it correct that some of these companies actually own the whole thing, so they're really not co-located, they're owned, they're singularly owned by different sub-corporations, if you will, of the same major corporation. Isn't that correct? And isn't that part of the concern? I don't mean to get too in the weeds, but I'm really trying to figure out, I mean, it's been 20-plus years, and so maybe I'm not...
Pulling me up because I've been doing 15 of it. So, and it's been, you're right, it has been 20 plus years. And you are correct. There are about 1,000 doctors practicing in these models and have been for 20 to 25 years.
But when you say models, what are you talking about?
Correct, sure. So I just wanted to clarify how many, you had a question earlier about how many have been practicing. So, so a co-located model can be many different things, a couple of different things I'm going to stay focused on. So there, in California, we register our dispensing opticians. So they're the ones who make, manufacture, and dispense the frames. And then we have practicing optometrists. So for the company I represent, Eye Exam and Lens Crafters, Eye Exam is a health plan that is located next to a registered dispensing optician. And the health plan then employs the optometrist to provide service.
Who employs the optician?
The optician is employed by Lens Crafters.
And so does Lens Crafter also have a relation, a corporate relationship?
They're sister companies.
They're sister, okay.
They're sister companies.
Isn't that the concern, is that you've got the doctor doing the examination, selling a product that is owned by a sister corporation? So the doctors in Eye
Exam of California do not sell frames and lenses. So the Eye Exam of California doctors only provide services and do contact lens fittings. They do not sell, benefit from, or anything of the nature of a frame and of the lens.
But don't they, after they do the exam, then say here and write, you know, aisle 10 next to aisle 11 is the Lens Crafters, the company, and here's a prescription for you.
There are no aisles, but Lens Crafter. Yeah. But that gets to the other point where there are other models. So Walmart, for example, has a couple different ways in which they do that, and I'm going to graciously speak for Walmart, if that's okay. They are both registered dispensing opticians and then sublease the space to a company who has a health plan and also employs their docs. Or they sublease the whole space where that company is a registered dispensing optician and then separately has a health plan who employs their docs. Costco has a different model. They sublease to a company who then subleases to a doctor, and then they are registered dispensing opticians. If we're looking outside of private optometry, which is really what this bill, or sort of the conversation we need to talk about, then there are other models out there as well, including Kaiser and the like. So the bill is really about how we're going to statutorily having the conversation, the time for a diligent conversation, so we're not back here for the next 5 years, giving the conversation time to consider all the different models and build a statutory framework around that. So then the regulators can regulate. The difficulty is we have been in litigation for 25 or 15
there's
years.
A linchpin here that's I'm looking for. What is that concern? That
the concern is that the concern is the optometrist and optician either being employed or either being connected in some way to prevent that undue influence. In the models now, they are sister companies. So again, the optometrist doesn't sell frames or lenses. But the concern is that there would be influence over if they're in sister companies or something like that. So we need to build, and 595 is about the statutory framework that would prevent that type of influence, so much so that you can regulate against it. So in 595, there are provisions that prohibit, an incentive-based system on frames and the like, which is not considered in statute now. So that is the goal for 684, is to really understand the dynamics of how optometry is provided today outside of private optometry and build a statutory construct around that.
And to the author, last question, is that your goal, and how are you envisioning making that happen?
Well, I think one of the other goals too was also on the side of regulation and actual enforcement, meaningful enforcement. And originally, I think there was a bill that was cobbled together. I don't think it would have brought the other side to the table. It probably could have been pushed through by the sheer force of it. I felt it was better to try to get both sides actually in agreement, so we weren't right back where we are today, and also to allow time for the Board of Optometry to work with the medical board and straighten out the reporting of infractions so that there could be a meaningful enforcement structure. So we worked with the administration, with DCA as well, because they understand that there are concerns on their ability at this point in time to properly enforce And that's a little bit of a complicated issue about with the insurance being involved, that some of the complaints are sent to the Department of Managed Health, not to the Board of Optometry. So the Board of Optometry is in the dark. And here we're saying, but we need to get this all enforced, and we want everyone to be following clearly what the new model will be, but we don't know the new model, and we don't have the system in the back end working out so that those complaints would actually be enforced against.
Okay, so to the chair, is it my understanding then that if we vote to move this along, it will come back to us if there are amendments made prior to it getting to the floor, if it were
If the
to be?
amendments are made on the floor is the issue. We will have to talk to the Rules Committee if it goes to appropriations, which it will be.
Okay.
And the amendments are there, then that would be it.
Okay, thank you very much.
And I would say that, both be, I'm sure, in agreement with bringing it back. It's, something that we would, if they can come together and we can get this agreement, it's something you'd certainly want to hear the details of.
Yeah, and I think we really would want to do that, so I appreciate that.
And I think that over the summer break, and if we could employ like a mediator to help work, move these conversations along, we're committed to work through that, and hopefully reach a goal if that's possible at this point. But that's the commitment there.
Thank you very much. That's
Mr. Chair.
Yeah, sorry?
Just a quick question.
Yes, of course.
Comment.
Senator Berryhill.
Yeah, this, as Senator Jackson mentioned, this is a very, very complicated issue, but obviously the stakeholders have been working on it. I think we'd be doing a disservice if we didn't move this along. This bill will come back to us if there's major amendments. I'd like to move it at the appropriate time.
Very good. I think it may be the appropriate time, Senator Galgiani.
I had the advantage of meeting with individuals about the bill, so I think I understand it better. And I also used to work in the physical therapy field where there was a prohibition on having a registered physical therapist work in a doctor-owned clinic, whereby the doctors who made profits from the clinic could make a profit from whatever services were charged by the therapist. So I have that frame of reference, but I think one of the important things too that we haven't focused on as much that would be of benefit to the committee is to talk about the concern for access, and if the whole system were turned on its head right now to try to just conform to something, that you would have a lot of businesses having to stop business right now, and access would be an issue. And I think that's an important argument.
Thank you, Senator Galgiani. I think that's an important, it's certainly important, the idea of having the time to do it in the correct manner, in the right way, so that we don't have that dislodging in industry or many of the doctors that certainly testified today and that are around the state, I think is important. And the other aspect, I think, Senator Jackson, thank you for mentioning the fact that consumer protection is really what this committee is about. And that's the important part and aspect of this, and we can't lose sight of that in the negotiations as well to make sure that they're protected too. So thank you. Yes, Senator Hernandez.
Comment. I don't disagree that access is important, or if not the most important thing. And I'll be the last person to say that I would want to change anything from with regard to having any entity leave the state of California. My concern is that there won't be a resolution. And considering that it's been going on for close to 20 years, my biggest concern is the independent judgment of the provider. I don't care what setting they're in. So if you notice all these young optometrists that came up that flew in from all over parts of the state, they all said that they were employed optometrists. So for me, the most important thing is the independent judgment is sacred, that their judgment isn't going to be unduly influenced by their employer, okay? So I have no problem with a work in progress, but here's my concern about this particular bill, the way it's written. If no resolution is come to between now and the floor, and this gets signed into law, you're essentially allowing an entity to be here doing their business, which supposedly a moratorium against the law. So we're condoning that. That's the concern I have. I would much rather work this out now. So the concern I have is voting on a bill that gives them a free pass. That's my only concern. I would commit to working with you to try to get it, it resolved, and I think the opposition is trying to move in that direction right now. But I can't vote on this bill, and I'm going to lay off just because it gives this entity a free pass in the interim. I'd much rather have a resolution this year.
Very good. Thank you, Senator Hernandez. Other comments or questions? Seeing none, would you like to close? Assemblymember Alejo?
Well, I do just thank you very much for your questions, and it is a complex issue. It's certainly our hope to have a resolution as soon as we possibly can, and I think that already 684 has shown that it's been a prod in that direction, and there's even been, I think, shifting among the different groups as the summer has and the last months have gone on. I want to make it clear, though, that there is nothing in the intention on my part or Assemblymember Alejo's part to grant free passes, to allow illegal activities to continue. We're really seeking a solution that doesn't do any harm to the consumers, that does not harm California businesses, and that brings about a very clear business practice and very clear business model that is fair and workable and that maintains the access. Thank you for mentioning that as well. That is so important to many people in this state to good eye care. That's certainly the intention. It's not to favor one side over the other. I said this reminds me of settling disputes at home frequently, where you just want everyone to finally sit down and say, we're going to work this out. We need to do that for our constituents, and that's certainly the intention of bringing forward the safe harbors, to give us the space and the opportunity to do it correctly, and it's the best possible policy solution that we can come up with.
And certainly the access of 2 million Californians who utilize these places is of utmost importance, as is the consumer protection. But I remember when I was an assembly fellow here in 2002, when I had no health insurance, the only place I could go to have get my eyes checked and get some new pair of glasses was at one of these places that we're talking about. It was available in the evening. It was affordable for somebody who had no other option to go get that kind of care. So I know from personal experience, my story is a story of so many other Californians in this state, but also the many people who work there and the jobs that they create for our economy. So as our commitment was to keep working through this, hopefully the next 2 months, and find that goal. But this is only about 1 additional year. It's not going to be prolonged more than that. And the commitment is to get this resolved once and for all and not have any more delay. And I look forward to working with all of you to achieve that.
Thank you, Assemblymember Alejo. I appreciate that. And I think it's clear that the committee certainly has an interest in this, and we'll be watching and looking forward to seeing it again at some point. And we have a motion from Senator Berryhill to pass to appropriations. Please call the roll.
Hill.
Aye.
Hill, aye. Bates. Aye. Bates, aye. Berryhill. Aye. Berryhill, aye. Block. Galgiani. Galgiani, aye. Hernandez. Jackson. Mendoza. Aye. Mendoza, aye. Wachowski. Aye. Wachowski, aye.
6. Bill has 6 votes. We'll hold the roll open for absent members. Thank you very much. Thank you. We have the consent calendar, item number 8 and item number 15. Is there a motion on the consent calendar?